Hello and welcome to this edition of Company Law Lectures. In the last lecture, we had gone through section 52, which spoke about that shares can be issued by a company at premium, and within which we saw that the Companies Act under section 52 allows the company to issue shares at premium, and the amount of premium shall be transferred to securities premium account or share premium account. And we also saw what is the utilization of such share premium account or securities premium account created by the company. To understand the concept of securities premium account in detail, do refer to my last lecture, which I will also give you on the I button over here. In this lecture, we will be going through section 53, which speaks about issue of shares at discount. Without wasting any time, let's get into section 53, which shall be prohibition on issue of shares at discount. What do you mean by prohibition? Prohibition basically means it is not allowed, which means that issue of shares at discount is not allowed by the Companies Act. Whereas issue of shares at premium is allowed as per section 52. So coming to section 53, the company shall not issue shares at a discount. This is the crux of section 53. But there are two exceptions which have been provided under section 53 itself. What are these two exceptions? The first one is company may issue shares in the form of sweat equity shares. Now, what do you mean by sweat equity shares? Sweat equity shares are such shares which are issued to directors or employees of the company for their know-how which has been provided to the company, or in lieu of some consideration other than cash. We will discuss this section 54, or that is sweat equity shares, in detail, which will be my next lecture itself. So you will be able to understand the whole concept in the next lecture. For all these lectures, request you to subscribe to this channel so that you get all the lectures of company law. Hence, the first exception is issue of sweat equity shares by the company. The second one is issue of shares by the company to its creditors against the debt which is due to the creditors. That means against the debt, the company will provide equity shares. That means there will be a conversion of debt into equity shares. So it is nothing but it is a conversion of debt due into equity shares, and such shares will be issued to the creditors of the company as per the statutory resolution plan or debt restructuring scheme. As per the statutory resolution plan or debt restructuring scheme, which will be approved by RBI under the RBI Act. So I hope this is clear to you. So this, the second exception, says that the amount which is due as debt to creditors will be converted into equity shares of the company by issue of such equity shares. In that case, the company may issue equity shares at discount to the creditors also. So there are two exceptions: sweat equity shares and conversion of debt into equity shares of creditors at a discount. So both these exceptions, I suppose, is clear to you. Now, in case the company still goes ahead and issues shares, company issues shares at a discount. In that case, such an issue will be void. And since it is void, any money that is received by the company under such issue shall be refunded by the company, to the respective applicant or shareholder. I hope this point is clear to you. Now, in case the company issues shares at discount, which is prohibited, since it is prohibited, there will be a penalty which the company and the officer in default will need to pay. What will be the penalty? The penalty will be amount which is equal to the amount which is raised under such an issue of shares at a discount. I hope this is clear. Or rupees 5 lakh, whichever is less. Or rupees 5 lakh, whichever is less. Remember this thing, whichever is less, not whichever is more. Okay, so the amount which is raised through the issue of shares at discount or 5 lakh rupees, whichever is less, will be the penalty for both company and the officer in default. Now, the last point is that what I had already explained it to you, that if the company issues shares, then such an issue is void, as well as the company will have to refund. Company will have to refund. So the clause for the same is the company is also liable to refund all monies received by it with an interest of 12% per annum, with an interest of 12% per annum from the date of issue. So this is section 53. Just to recap it fast, section 52 says that a company may issue shares at premium. Whatever premium is received shall be transferred to share premium account or securities premium account. That shall be utilized as per section 52 itself. At the same time, section 53 is a prohibition to the company for issue of shares at discount, which means company is not allowed to issue shares at discount. If the company still issues it at discount, in that case, it will be void and the company will have to refund it to the shareholders or applicants at with interest of 12% per annum. And still, if the company goes ahead and issues shares at discount, in that case, there will be penalty to the amount which is raised through such an issue or 5 lakh rupees, whichever is less. I hope this section 52, section 53 is clear to all of you. In the next lecture, I'll come up with section 54, which is sweat equity shares, and we'll go through sweat equity shares and its conditions in detail. So stay subscribed to the channel. If you have understood this video, please like this video and share it to the maximum of your friends and groups. That's it for this particular edition. Thanks a lot.